Thanks, Deborah. Hi, everyone. Christina Moon. I use she, her pronouns. I'm a senior attorney at Education Law Center of Pennsylvania. Really appreciate the chance to connect with all of you who are working in the education field. And as Deborah said, I think I'm really glad we had this on the calendar. When I previously thought to just walk through what the new regs say and require of schools, we now have a bit of a wrinkle to make sure that everybody understands following the injunction in the Kansas case. So what Title IX regs require of schools and the Kansas case is a lot for this period of time, but I'm going to try to move through it quickly enough to allow a little time for questions and discussion, because I'd love to hear what you all are thinking about, and any questions that you're getting from schools, for those of you that are solicitors, all of that. So maybe I don't know what the committee's usual practice is for presentations, but like questions in the chat to review and consider after I get through the slides could work well, I think. Okay. Whoops. I don't think I'm actually going to walk through in this order, but we'll cover Title IX and the 2024 rule, the legal challenges to that rule, including the Kansas versus Department of Education case and its application in Pennsylvania, which implicates also, or we should address relatedly, the Pennsylvania Human Relations Act provisions. And I did want to also flag the main provisions of the new rules. But as I said, all of this could take up additional sessions if folks are interested, or in another venue. I believe you all know Education Law Center, so I'll skip through here. Just a flag here at the front of the context why it is so important to be talking about these issues. One of them is certainly that school efforts to affirm and support trans students are life-saving. And so I like to make sure that we're all thinking of this in the context of this discussion, which can, as all legal things, get kind of academic perhaps. But here really we're talking about what the Third Circuit has recognized. Transgender students face extraordinary social, psychological, and medical risks, and school districts clearly have a compelling state interest in shielding them from any discrimination. And in fact, we know from the research that school-based supports can save lives, can make a real difference. For instance, research shows that LGBTQ young people have reported having access to at least one space that was affirming reduced their odds of attempting to die by suicide by 35%. And just using a student's correct name and pronoun decreased thoughts of dying by suicide by 29%, and attempts to die by suicide by 56%. So in fact, what we do in schools really matters for students most affected by this discrimination. You all know Title IX, just the basics here. Of course, it applies to all public schools, including charters and approved private school placements through the IEP process, and covers a variety of circumstances, including sexual harassment, athletic opportunities, sex-based discrimination in courses or programs, treatment of pregnant and parenting students, LGBTQ students, any discriminatory discipline based on sex, and hostile environments created by sex discrimination as well. So a little bit about the regs. You may recall there were final regs implemented through the Trump administration in 2020. We then had proposed regulations from President Biden in 2022. After 235,000 comments, that period was closed in September 22. And in the intervening time before the final rule, we got a proposed athletics rule in 2023. Another 150,000 comments on that athletics rule, which were closed in May 23. And then in April of this year, we got the final 2024 rule published, and have seen lawsuits challenging those regulations and injunctions in those cases. And And now we're at or past the effective date of August 1 for that 2024 rule. So just a flag, and then I'm going to come back to this, but those 2024 Title IX regulations, I think of in kind of three big bucket or issue areas. One relates to LGBTQ students, another relating to pregnant and parenting students, and the third can be kind of clumped together in due process protections about notice, and how the complaint can be submitted, how the investigation is carried out, and requirements for what kind of action the school has to take upon a complaint. Shifting then to the challenges to the 2024 Title IX rule. This handy visual is from Ed Week, which does have a pretty good updated primer on all of the legal challenges nationwide. I'm not going to go through all of the nationwide challenges, but there have been 8 initiated by other states seeking to prevent this rule from taking effect. And in each of those cases, courts have ordered an injunction on the entire rule, which we'll also talk about. So that is 26 states where the rule is enjoined. Pennsylvania is not a party to any of these lawsuits challenging the 24 final regulations. And in fact, our AG Henry submitted or joined an amicus brief supporting the Title IX rule in the Kansas case that we'll talk about. There is no universal injunction nationally, but because of the Kansas case specifics that we'll address, the rule is blocked in addition to these plaintiff states from effect in any school nationwide where there are members of these few organizations that were plaintiffs in the Kansas case. That's Moms for Liberty, and Young America's Foundation, and Female Athletes United. All of these injunctions have been appealed, and the Ed Department is seeking partial relief for the non-gender identity provisions. So just a little bit of context, as you might expect, or have seen in the news, all the lawsuits take issue with the Ed Department's decision to expand or confirm and clarify, consistent with case law, that the scope of sex discrimination includes gender identity. They argue that gender identity is too vague a term to be included in the regulation, that the Ed Department's forcing some students and staff to go against their beliefs by allowing trans and non-binary students to use bathrooms and locker rooms that align with their gender identity. And while the Ed Department justified the regs in part using the Supreme Court's Bostock decision, which of course said that employers discriminating against employees on the basis of gender identity or sexuality violate Title VII, the lawsuits argue that Bostock doesn't apply to Title IX explicitly. Also, 7 of the 8 lawsuits argue that the rule opens the door to inequality in athletics by giving trans girls access to girls' sports. That's not the case this explicitly anyway. The Ed Department says this rule doesn't apply to athletics and is reserved the proposed rule on athletics for a separate process that we don't have a final rule for yet. On the appeals, as I said, the Ed Department has appealed all the injunctions, and in the first couple that came up, in the Louisiana case and the Tennessee case, the Ed Department sought to stay those injunctions, but both the 5th and the 6th circuits have refused to overturn those injunctions. So the Ed Department requested emergency intervention from the US Supreme Court, asking them to set aside the parts of the injunction that don't relate to gender identity provision of the rule, arguing that the lower courts plainly erred in enjoining those dozens of provisions that the state plaintiffs did not challenge explicitly, and that the courts did not find likely unlawful. We do not yet have any action from the Supreme Court on that request for emergency intervention. And of course, we have passed the August 1 start date. So the particular case that has some application in Pennsylvania is Kansas versus the US Department of Education. The plaintiffs in that case included Kansas, Alaska, Utah, and Wyoming, and those national organizations that I mentioned. Moms for Liberty have been in the news. You probably are aware of them. They're a conservative organization active in school board politics. Young America's Foundation is another organization for young conservatives, mostly at colleges and universities, as far as I can tell. Female Athletes United is another conservative advocacy organization. The holding in the Kansas case resulted in an injunction on the 2024 Title IX rule in its entirety for those plaintiff states and the organizational plaintiffs, including Moms for Liberty. So the application here is that the U.S. Department of Education cannot enforce the 2024 Title IX rule in individual public schools that have students attending whose parents are members of Moms for Liberty. And there's actually a list of schools. There's now two partial lists that have been submitted by Moms for Liberty, docketed on the court's docket. And we at Education Law Center have taken the lists that have Pennsylvania schools and attached them to our analysis fact sheet. I don't know, Deborah, if that's been shared already, but we could also put it in the chat. ELC's analysis that has the attached list of schools. We're going to talk about the list, but my main point is that it doesn't actually matter if you're on this list, because the court case, as I said, only enjoins the U.S. Department of Education from investigating a complaint that may be filed and enforcing the 2024 rule on a particular school. And we have other obligations of schools that continue despite this injunction. Of note, the U.S. Department of Ed has appealed to the 10th Circuit this decision already. So I've tried to excerpt here a piece of the Kansas decision that I think really needs to get attention in any discussion about the Title IX rule and its application or injunction in Pennsylvania. So first is the first highlight is the court's reasoning for application in an unusual broad fashion to include members of the plaintiff organizations outside of the plaintiff states to national members. And then the second piece that I've highlighted here really explicitly points to a couple of pieces that are going to be very important for schools and parents to understand. The first is that there's nothing in the order, it says, that limits the ability of any school to adopt or follow its own policies or otherwise comply with state or local laws. So we do have applicable relevant state law here. And the Pennsylvania Human Relations Act, the PHRA, and its regulations explicitly prohibit discrimination in schools based on gender identity and expression and sexual orientation. And so all of our schools continue to be liable under those same provisions, which of course mirror the 24 Title IX regs that are in dispute here about sex discrimination, including sexual orientation and gender identity and expression. And as we'll talk about a bit, pregnancy and familial status also. We also have pre-existing controlling case law under the Title IX statute itself, not the regulations, but the statute. In the Third Circuit's case in Boyertown, the decision from 2018 that held that there is no violation of cisgender students' privacy rights in requiring the students in that school to share bathrooms or locker rooms with transgender students. There was an affirming policy in Boyertown that allowed for use based on gender identity, and some cisgender students or parents brought a challenge to that policy. That case did not have to address Title IX explicitly, because it was an affirming policy itself. But there's very broad language from the Third Circuit affirming the rights of trans students here. And that was actually, a cert was denied in that case from the US Supreme Court as well, letting stand the affirming decision for trans students. So that pre-existing controlling precedent still applies for schools in Pennsylvania. And the final point is here that the Kansas decision doesn't require any school to stop or change policies or practices that affirm the rights of LGBTQ students. So, you know, we've gotten some questions on this position, thinking that, you know, schools have to stop whatever supportive policies they have in place. But in fact, of course, the injunction applies only to the U.S. Department of Education, and prevents them from enforcing the 24 rule if they get a complaint from a particular school that is under the injunction. A little procedural history, so you know where the Kansas case is at. That injunction was ordered on July 2nd. The plaintiffs were ordered to submit a list of impacted schools, and the court did explicitly note that future members are also entitled to an injunction, which anybody working with schools or I suppose applying an injunction in most any context can imagine what a mess that sounds like. That a school could be subject to injunction of which they have no formal notice, just because a parent comes to them and says, I'm now a member of Moms for Liberty and this court case applies to me. But at this stage, we do have a list of members submitted by plaintiffs' Moms for Liberty to the court, but we don't yet have a final injunction order from the court with, you know, like incorporating that list of schools. Through multiple filings, because there were extensions of deadlines, the plaintiffs have currently identified a total of 244 Pennsylvania schools, because again, the court order was to identify particular school buildings, not school districts, which suggests to me very little understanding of how policy and practices are implemented in school districts. They come from 85 school districts and 3 charter schools across the state. And again, we'll share these slides, which link the fact sheet here, and you can look at them from our website to find out which schools and school districts are affected. Next up in this case, the U.S. Department of Ed is to respond to the complaint by August 26th. And there was a filing on the 2nd with a joint status report proposing a schedule after the PI decision. It looks like dispositive motions should be briefed by September or October. There's some difference in opinion about how that proceeds between the parties. So since I've suggested that the PA Human Relations Act is very important here, I thought a little refresher might be useful. The state's anti-discrimination law prohibits discrimination in public K-12 schools as a place of public accommodation over which the PHRA applies on the basis of a number of categories here, including sex, which is defined to include gender identity expression and sexual orientation. Generally, cases have construed the parallel provisions of the PHRA to be coextensive with their federal counterparts. Specifically from the PHRC, the commission, there was guidance in 2018 that that directed that sex discrimination would be interpreted to include gender identity and transgender status. There was actually final regs adopted in December 2022 that formally include in the definition of sex discrimination, sexual orientation and gender identity and pregnancy. We have also some explicit statements from the PHRC, one in January 23, where they were monitoring complaints and allegations of LGBTQ and specifically trans student discrimination in Central Bucks, for example. And then recently in July, in response to the Kansas decision, there is a joint press release from the Pennsylvania Attorney General and the PHRC about the Kansas decision. I've linked it here, and it's also linked in ELC's fact sheet resource. They talk about the decision of the Kansas case. It's limited application in Pennsylvania, which is consistent with what I've described here. And the PHRC says, you know, we stand ready to receive and investigate complaints of sex discrimination on the basis of gender identity, expression, and sexual orientation. You know, as you may know, the PHRA has not been as extensively litigated as Title IX for sure. So there is not as much case law interpreting the act, but we do have, for example, a 2018 decision where, oops, sorry, I just lost my screen. There we go. Where a Pennsylvania court held a school responsible under the PHRA for indirect discrimination in its failure to intervene with peer harassment due to a student's gender presentation. So interpreting the PHRA for gender identity discrimination. And there was a $500,000 damages award against the school, plus I think another $500K for attorney's fees. In that case, I'm doing okay on time. So I was going to move at this point to actually talk about what the Title IX rules include in broad strokes. Deborah, is that okay? Do you want to pause for any questions on this stage? Okay, let me get a little bit more so that now you see that even assuming a school, the many schools that are not on this list of injunctions are responsible for this 2024 Title IX rule as of August 1st already. So we're going to walk through some of these particular rules. And of course, we would advise that, you know, we all know there's like no grace period for compliance once the appeals are run. So a school will have to be immediately compliant with the new 2024 Title IX rules if the U.S. Department of Ed wins on its appeals of these injunctions. So we certainly advise that schools be compliant with these 2024 Title IX rule provisions now, not just because it is good practice that affirms students and it's also consistent with the PHRA, but because they'll be obligated to be compliant once any appeals run. Okay, so just a few highlights of those 2024 rules include, as we've talked about, this definition of discrimination is clarified to include sex stereotypes, characteristics, pregnancy or related conditions, sexual orientation, and gender identity. It's a shift from prior focus on sexual harassment to sex-based harassment, which broadens the application and the types of incidents that could fall under its purview. There's also a shift here to prohibiting unwelcome sex-based conduct that's so severe or pervasive that it denies or limits its individual's ability to participate in an education program or activity, which you can see from the comparison is, I think, a meaningful distinction from the 2020 rule. It also broadens explicitly to cover peer retaliation by other students as prohibited retaliation. Defined in the rule, retaliation means intimidation, threats, coercion, or discrimination for the purpose of interfering with any right or privilege secured by Title IX because the person has reported information or made a complaint or testified, participated in a hearing, for example, or an informal resolution process. The specifics regarding application to gender identity and sexual orientation for the rights of LGBTQ students are cited here with the CFR numbers. It also is explicit that schools must allow students to participate in classes and activities, to use bathrooms and locker rooms, and to apply any dress or grooming codes to themselves consistent with their gender identity. There's language saying that any of these distinctions cannot cause more than de minimis harm. And the rules language is clear that denying access to facilities that align with gender identity, for example, is more than de minimis harm and prohibited by Title IX. Regarding pregnant and parenting students, and I'm doing a real disservice here with these few bullets, but we will also have a more detailed fact sheet resource from ELC, I think the end of this month. So we'll share those around to the committee or section as well. But big picture, pregnant and parenting students under the rule are covered on the basis of any past, potential, or current pregnancy, childbirth, termination of pregnancy, lactation, recovery from pregnancy or related condition. And there's language that these pregnancy-related protections have to be fully integrated into all notice and complaint processes and forms to be very explicit about this coverage. Schools cannot require a student who's pregnant or has a related condition to get approval from a healthcare provider to participate in any programming unless that's required of all students. And this is a significant change from prior policy and practice. Schools must allow a voluntary leave of absence for at least as long as the healthcare provider deems medically necessary, and they have to be reinstated to their prior academic status. Schools have to provide reasonable modifications for students based on pregnancy or related conditions that are individualized and voluntary. So they can't be forced to take any modifications or changes in schedule. And some modifications could include elevator access, a larger desk, a footrest, breaks from class, absences, online courses, again, if voluntary. Schedule changes, again, if voluntary, extensions, reschedule exams, counseling. Schools have to provide private, clean, and this is specified, non-bathroom lactation space for students who need it. I just realized I don't have a site for you here of the individual CFR, so that'll be in the fact sheet as well. And then in the additional kind of bucket of due process provisions, again, more detail in some resources forthcoming, but complaints under the new rule can be verbal and informally written to trigger responsibility from the school. The school has to, address harassment or other sex discrimination regardless of where the underlying incident occurred, if it creates a hostile environment in a school program, in the building, or something under the school's disciplinary authority. Previously, it was occasions only. Sorry, I think somebody maybe needs to be muted. I don't know if another host can do that. Previously, the context for triggering liability was if it was under the school's substantial control. The third bullet here, schools have to address complaints if the complainant was participating in or trying to participate in school at the time of the incident. The prior rule trigger was about when the complaint was filed, if a student was participating or trying to participate. The school must respond to any conduct that may reasonably constitute sex discrimination through prompt and effective action, and that's a change in language from the prior rule that required actual knowledge of allegations and required response in a manner that was not deliberately indifferent. Schools must use a preponderance of the evidence standard to adjudicate guilt and may opt for a clear and convincing standard if the higher standard is used in comparable proceedings. That is also a change of evidentiary standard. The prior rule required the more difficult, clear and convincing if it was used in similar proceedings. Title IX coordinators, investigators, and decision makers under the new rule have explicit requirements to not have a conflict or bias against either party if they're going to be involved in the proceeding. The previous rule had no limitations or parameters on officials with conflicts. Okay, that's the end of my sprint through the new rule and the Kansas decision. I have a number of slides also that we use to talk through like common issues ELC has seen presenting for LGBTQ students and the case law at this stage about those issues. But I think maybe I should pause here to ask if there are any questions or comments, discussion about the rules themselves and the Kansas decision.
Christina, just a question about the Kansas case. You had described the new rule as sort of addressing like 3 buckets: the LGBTQ, the pregnant and parenting students, and the due process protections. Were the plaintiffs in that case targeting one particular area, or was it sort of an attack on the entire rule?
Yeah. From what I have seen, the complaint allegations in each of the suits challenging the 24 rule were really focused on the gender identity provisions. And yet the injunctions in each of the cases apply to the full rule. And that is the basis of the Department of Ed's emergency relief sought from the US Supreme Court, asking, acknowledging there's something to litigate about the gender identity provisions, but the injunctions are overbroad, and there were not complaints about the other provisions of the final rule. And I think in the cases that I recall, the decisions also don't actually find likely unlawful the other provisions. Like they're really focused on the gender identity, but apply to the whole rule, which is a real shame, because it ties up a lot of other good, actionable provisions in this kind of confusion. I will say that, or I'll repeat that the PHRA does also apply to pregnant and parenting students' rights in school, includes pregnant students in the prohibition of sex discrimination under the PHRA. So like effectively, while it's not litigated in the detail that we have in the 2024 Title IX rule, I would advise schools to get in compliance with the 24 rules pregnant and parenting student provisions, because they are consistent with the PHRA's prohibition on sex discrimination for pregnant students. And then it's like the due process provisions are just left hanging, which is a shame for students that really can use them. I'll share one question that was shared with me from the PHRC. They've gotten parents and schools apparently asking how they get off the list. Like, how do they apply to get off this list of Moms for Liberty identified schools, which of course, like, is not for parents or schools to do. It is being appealed by the US Department of Education. But I think that was a flag to me of how much misunderstanding there is about this list, about how it came to be, what it means, and really calls for some real clear advice and counsel from the legal community.
Hi, can you hear me?
Hey, yes.
I was just wondering, for schools where the rule has been enjoined, they have a parent who's a member of Moms for Liberty, even if they use the expanded definition of on the basis of sex, which they probably were anyway, should they be following the 2020 procedures or the 2024 procedures? Or is that just one of those questions that's up in the air? Because I'd be a little concerned about getting dinged for violating the defendant's due process rights if you didn't follow the old rules.
Yeah, and you're speaking specifically about the process, the due process.
Yes, the process.
Yeah. I think there's a lot of uncertainty on this in that area in particular. So while the 24 rule is enjoined, the 2020 rule is the law. So I think that's the obligation of schools who are on the injunction list in terms of the process requirements.
Christina, I am looking at the list that was attached to, I think, the fact sheet that was included in the email about the presentation. It looks like the Pennsylvania list sort of starts over. Were there like two separate lists that now you have to look at both of them, or did one?
Yeah.
Other?
Yep, there was an initial deadline that was there was initial filing of only 6 Pennsylvania schools, to which I thought, I'm aware of more than that with Moms for Liberty members. And indeed, with their requested extension, they submitted the first list you see. And then the plaintiffs also filed, like on the 31st, trying to get in before the August 1 effective date, the last section that you see. So what you have in those 2 pieces attached to Education Law Center's fact sheet are the lists of Pennsylvania schools that appear on the docket, but they are not in a convenient order. Any other questions about Kansas or the 24 rule?
Just one question. Is there any place that has had any challenges to the due process changes?
Do you mean lawsuits, Michael?
Yeah. Mm-hmm.
No, not that I am aware of. All of the challenges really are focused on the gender identity provision. But as I said, the final injunctions apply to the whole rule, including the due process provision.
And of course, nothing forecloses a defendant who feels they've been adversely affected by them from challenging at the time they're applied. Is that correct?
Say more about that.
Well, defendant who thinks he's been adversely affected by the change in the evidentiary standard, for instance.
If they were to apply the 24 rule?
Yeah.
Yeah, sure. Though, to be clear, the 24 rule is effective in all schools that are not on this list. So
but
the
even
24
in those
rules requirements.
Right, even in those states, the defendant can presumably, I mean, a person who's facing an accusation can presumably challenge that if it got to some place where they were subjected to a penalty.
Individual, yeah, sure. Okay. Would it be useful to walk through some of the slides about the Title IX case law and school application? I'll try to share again. Okay. So then, given the context that even for schools that are under the injunction and not under the 24 rule, they are subject still to the case law interpreting Title IX before this 24 rule. So that's the basis for sharing this information here. And we start, of course, with some of the Supreme Court context, which Bostock we've mentioned before. And I like to note that at least 4 times in the last 5 years, the US Supreme Court has declined to review cases that are challenging school policies supporting trans students, like leaving in place the lower court decision that affirms students' rights. And those are a 7th Circuit case AC, Grimm in 4th Circuit, Parents for Privacy in the 9th Circuit, and Boyertown, which I previously mentioned, from the 3rd Circuit. In the context of privacy in school records, this isn't so much under Title IX, but we talk about it as like a foundation for schools' interaction with students. And the foundation really is that gender identity is a deeply rooted element of a person's identity. That sincerity is really like one's religious belief and should not be disputed, should be generally presumed or easily established. So school districts should accept and respect a student's assertion of their gender identity where that student expresses the identity at school or where there's other evidence this is a sincerely held part of their core identity. There have been some challenges to a purported right to privacy challenges to policies at schools that seek to affirm students' gender identity and work with students to describe their request to the school, also to their parent. And the challenges are, as you may have seen in the news, you know, a parent of a cisgender student says, there's a policy that suggests the school will keep a secret from me and not tell me if my child tells them to call them a different name and pronoun. Those types of cases across the country have been rejected on standing grounds. There's some in Pennsylvania that are still being briefed at different stages. We get a lot of questions and opportunity to clarify that there is actually no requirement in FERPA to notify a parent. You know, only provides parents the right to view the school records of their minor children, but doesn't actually require schools to proactively contact parents about any particular content or changes in a student records. What else have I got here? Oh, we've seen some policies statewide that newly suggest a birth certificate is required at enrollment or registration to prove a student's sex for enrollment or activities, which is of course no basis in state law. I'd appreciate any information if you see that, but certainly PDE guidance is clear that, you know, birth certificate is not required at enrollment for any purpose. And certainly not, there's any requirement to prove a student's sex for enrollment or activities. Bathroom and locker room access. This again is walking through the Third Circuit Boyertown case. Our controlling federal court in Boyertown said that there's no privacy violation in having trans and cisgender students share facility space, and a policy barring trans students from restrooms aligned with their gender identity would pose a potential Title IX violation, though, as I mentioned before, that was not decided because there was actually an affirming policy in place at that in that case. And cert to the Supreme Court was denied there in 2019. We also have these other opportunities to review and address this issue in the Middle District, in the Western District as well, that came out consistently for trans students' right to bathroom access here in Pennsylvania. And indeed, all other circuits except the 11th have been finding for trans students' right to access aligned with their gender identity. And the 2020 Parents for Privacy case I mentioned before was I think the latest Supreme Court cert issue on the bathroom piece. I also point out the Education Department's Office of Civil Rights has made clear they enforce Title IX, interpreting sex discrimination to include gender identity expression before these Title IX rules from 2024. A number of examples here, even from Pennsylvania. On sports participation. So as context, of course, we all have experience, and the research shows that there are significant benefits for playing sports, including test scores, school completion, teamwork, leadership, like school connectedness. And research has shown there's actually no negative impact on participation of girls in school sports in research of states that have implemented inclusive athletics policies. It is really only sexist stereotypes about how girl athletes should look or play that promotes body policing in these contexts. I think the closest case on point to sports in the Third Circuit is again Boyertown, which has very broad affirming language about discomfort not being an acceptable reason to deny equitable access. In the issue presented was bathroom or facilities, but it's very broad affirming language, and found there was no violation of the cisgender students' rights to share space and requirement to share space with trans students. There have, of course, been some sports cases in other courts, including the examples here. I think the latest was from West Virginia, the BPJ case, which in April this year, the Fourth Circuit ruled for the trans athlete that the ban in that state does violate Title IX. And then in Connecticut and Idaho cases in the Second and Ninth Circuit, there have been remands, but on like procedural issues, not the merits of Title IX application to sports in those cases. Yes, and then here I have some of the language of the department's proposed reg on sports specifically, for which again, we do not have the final rule yet. But the proposed rule said that schools would not be permitted to adopt or apply a one-size-fits-all blanket ban on trans students participating on teams consistent with their gender identity. It requires a multi-step kind of assessment of each team's particular sport, the level of competition, the grade, education level. But in application, it effectively would prohibit elementary, middle, and in most cases, high schools from adopting rules that prevent trans students from participating. And there's additional language that the criteria can't be based on disapproval of trans students or a desire to harm a particular student, that it has to minimize harms to students whose opportunity to participate would be limited or denied if not based on their gender identity. And then regarding name and pronoun, there is some case law in our district about the intentional and persistent misgendering constitutes sex-based harassment and creates a hostile environment in the employment context. So the Doe v. Triangle Donuts case that I've included there found that applying Bostock, that in addition to being misgendered, an employer dead naming a trans woman was sufficiently severe or pervasive to support her hostile work environment claim. And I've included also lists of OCR resolutions that found for the rights of trans students to have affirming name and pronoun use in the school context. And then the note here is just that as we've talked about, the 2024 Title IX rule reconfirms the right to name and pronoun use for trans students. There is a separate analysis, of course, for public K-12 teachers who may assert that they should not have to use a student's name and pronoun in school. I think that's addressing a student in class is part of a teacher's job. So Garcetti case line would control. It's not compelled speech because the employer can insist on a lawful message. The school has that compelling interest and responsibility to protect students from discrimination. That's explicit in Boyertown from the Third Circuit. And this is some of the broad language that I was referencing that I've cited in the bottom paragraph of this slide. The Third Circuit found not only would a policy, they're talking in that case about bathrooms, but applying here to pronouns, not serve the compelling interest that the school district has identified, it would significantly undermine it. Contrary position would very publicly brand all trans students with a scarlet T, and they should not have to endure that as the price of attending their public school. There are some cases, there's a Cluj versus Brownsburg in the Seventh Circuit that is, I think, still waiting to see if the Supreme Court is going to take that. That was a April 2023 case that affirmed the removal of a teacher for refusing to use a student's pronouns, found that the school did not need to provide religious accommodation that caused undue hardship on students and their education. There was evidence that the students and the staff reported emotional harm, disruption to learning environment from the teacher's comments and refusal to use the pronouns and names. And lastly here, mindful that any discrimination, bullying, or harassment on the basis of sex, sexual orientation, gender identity, or expression can create a hostile environment. that is severe, pervasive, and persistent, so as to interfere or limit the student's ability to participate and benefit from school. And this kind of catch-all category would take into consideration any discriminatory policies, the instances we've seen where there are things like pride flags being prohibited, and unaddressed peer harassment or bullying. And again, with the obvious, there's a reason that we're talking about affirming policies, and that's because they actually really make a difference in students' lives, and can indeed prevent real harm. So let me exit out and ask if there's any other questions in the last couple of minutes.
I have one more question, if that's all right. In your experience, have you seen a lot of school districts have LGBTQ specific policies with respect to harassment, discrimination, Title IX, or have those protected classes usually been incorporated along with like race, gender, or sex, age? You know, do a lot of people have standalone LGBTQ policies, or are they usually merged together with more traditional bullying, harassment, Title IX policies?
I think it's a mix. You know, the first caveat, of course, is that the law applies whether your policy is explicit about it or not. But I think, you know, so it would be okay to have a policy that just says sex discrimination, because we know in application it also includes gender identity and sexual orientation, pregnancy. But I think most that I've seen include the litany in the non-discrimination policy at large. And then in the Title IX policy, I'm forgetting the numbers, but in the Title IX policy could get into more specifics about, you know, these particular provisions. Those that have some schools have affirming practices without having a school board policy about it, right? Like the building principal, when a student is identified, tells them, great, you can use the bathroom that aligns with your gender identity. Like, I don't need an announcement about it. That is our practice of non-discrimination. But those schools that have an affirming explicit board policy usually are like a gender identity policy, I think, is the kind of vague heading. And I can share some examples. There's one at the School District of Philadelphia, 252, for example, that walk through the some specifics, including the right to access, how to change your like submit a request and you can change your name in the roll call and the student portal, and explicit reference to using bathrooms aligned with, and that any uniform can be consistent with your gender identity, those pieces.
Thank you.
Yeah.
Hello.
Hi.
Hi, Christina. I'm Jason Emler from the School District of Philadelphia, actually. It is policy 252, and we do have a reference guide as well that it's the policy and the administrative procedures are listed on our board website. It's a little awkward to get to. You got to go to like board and da. You got to jump all the links, but there is also a reference guide there as to what it is. But if anybody wants to reach out to me, they can, you know, they're welcome to, and I can, you know, help them find it or get it.
Thanks, Jason. I think the Philly district has done a good job of making clear there's like a Google form that's openly accessible to like submit your request for changing your name in the Google Classroom kind of stream of things, so that some of the questions that we get, like, oh God, we can't change the tech, it just automatically defaults to the name on your legal enrollment file. There are ways around these things that schools have to deal with, the way that they have to deal with all kinds of administrative hurdles. So I think that's another area that if you're getting those kind of questions, I would love to refer to the School District of Philadelphia. They figured it out. They can share how to do it on the tech side. And the other piece that I've talked with the PDE about is the reporting through PIMS, the gender or sex of a student. There's actually no requirement that that be some like certified biological sex. it is sex of a student, which is interpreted consistent with the law, and the law identifies sex to include gender identity. So we can just be reporting a student's gender identity through PIMS. It does not have to be biological sex. And I've had that conversation with folks at PDE who I'm hoping are going to clarify that for everyone, but that's certainly the conversations we've had.
All right, I think we've just about hit our 1 hour mark. Unless anybody else has any burning questions. I want to thank Christina for coming and talking about this really timely and interesting topic. I have a feeling that these issues will not, this is going to be an ongoing thing. So, Christina, keep your calendar open for 2 o'clock on, on, I think it's the first Monday, Pam, of each month. We may need a quick update, if you're willing and interested. But otherwise, thanks so much for coming and talking with us today. So great to see so many people here. We'd love to have this many people every month. So if there are topics or things that you're interested in hearing about, or you'd like to speak on something, as Deborah said in the beginning, feel free to email us, and we'll get your topic on the list, and we can do it that way. So that's great.